Uber has a festering sexual assault problem. That's according to the New York Times, which published this article last week that goes through the high rate of sexual assaults that happen on Ubers. It discusses the knowledge that Uber had internally about correlations between certain types of rides, locations, circumstances, and sexual assaults in the Uber platform, and steps that Uber did take in some limited fashion, and steps that the article suggests Uber should have taken in order to prevent known sexual assaults on Ubers. I'm going to give you a quick overview of what that New York Times article says and then Uber's response, and then I'm going to get into the law. Here's the question as I see it. If your data flags high-risk rides on the system that suggest a likelihood or at least a potential of sexual assaults, do you as a company have a duty, a responsibility to do more to prevent those instances of sexual assault before they happen? My name is Shaunik, rhymes with Sonic. I've been a plaintiff's litigator for almost 10 years. That means I represent people, usually against government entities or corporations. One of my areas of practice is representing survivors of sexual assault. And when I do, I don't just go after the perpetrators, I also go after corporations or government entities that are involved. That means I routinely grapple with this question: does the corporate entity have a responsibility to do more to prevent sexual assault? Let's talk about that. The article reports 400,000 instances of sexual assault between 2017 and 2022 on Uber's platform. That's one sexual assault every 8 minutes. Uber, for its part, says 99.9% of its rides are incident-free, and that in fact instances of sexual assault are much rarer than have been reported, because that data that the New York Times reported also includes things that Uber says aren't sexual assaults. They're less serious, non-physical intrusions. I want to talk about that, but before I go any further, I'm going to be talking about sensitive things here. I'm going to be using words that, while we use in the law or clinically appropriately, may be triggering for folks who are listening and have had experiences as survivors in the past. So just want to give a trigger warning before I get into it. I hear defendants break sexual misconduct down into different gradations all the time, that this type of misconduct wasn't as severe as this type because it didn't involve actual sex, it was just touching, or this type was not as severe as this because it didn't involve touching of a couple of private sensitive areas, it involved touching of a different place, or this was less severe because it didn't involve touching at all and it was just verbal harassment or a threat to touch. I can tell you that that has never moved the needle for me, because none of my clients have ever said that they are relieved that their sexual assault was in one of the categories that the defendant has said is less severe and that it could have been worse. Still, a huge part of my job is making sure that I am looking at the field, evaluating the case, and making decisions that are in the best interest of my client at every step of the way. And so I have to be thinking about trial, the ultimate endpoint of this case. What will a jury do when presented with this information? Will a jury break down the different types of sexual misconduct in the same way that the defendant has? Will a jury view a certain type of sexual harassment in a less severe way as a different type? And the answer is most likely yes. There are a huge number of factors that go into that, hard factors and soft factors. The hard factors are things like, what do the facts say? What actually happened and what damage was caused? How egregious was the misconduct? Regardless of where it breaks down in the severity of the actual assault, in the totality of the circumstances, how bad was it? That moves the needle for juries. The soft factors can matter too, where the case is filed, right? Where is your jury pool coming from? Some counties, some districts, they may look at sexual assault and harassment differently than others. Sometimes it breaks down along political leanings and sometimes it doesn't. Your jury itself may be made up of all kinds of people with different views on sexual assault. And jury selection can be an adversarial process because both sides are taking their time and taking their turns to pick the jury that they believe is going to be a jury that best reflects what they see as the truth of the case, and that ends up becoming a jury that is a very, very mixed bag. It is a representative sample, ideally, of what the community would do, and that was the entire point of the jury system. So you never really can know what's going to happen. You can just do your best to make the argument and present the facts. Now, regardless of how Uber frames it, which is that a huge number of these were not actually sexual assaults, didn't even rise to the level of maybe even misconduct, the point is that it's clear from the article Uber knew there was something going on. Uber's internal teams mapped out the complaints and correlated them to various circumstances, like late night pickups, pickups near bars, pickups where the passenger was intoxicated, low rating drivers, repeat complaint drivers. And then they piloted some tools to actually address these issues, like dispatching Uber drivers based on risk assessments, having cameras in the cars, in-app audio during these types of pickups, women-to-women matching, since the huge percentage of sexual assault and harassment complaints were by women, although not all of them, and route deviation check-ins, because the teams may have found some correlation between deviations from prescribed route by a driver and instances of assault or harassment or misconduct. According to the article, early results actually showed that some of these interventions could be potentially effective in reducing or preventing sexual assaults or harassment on Uber. Uber, for its part, says there's no technological feature that we could implement that's going to prevent unpredictable human misconduct. Stick that one in your pocket for a minute, because I'll get back to that. Predictability, foreseeability, is actually a huge component of the law in deciding whether or not a company can be responsible for a third-party sexual assault. But one of the underlying legal tensions here, one of the reasons, and I believe a strong reason, for why Uber didn't and won't roll out universally some of these piloted features is because Uber drivers are independent contractors. The independent contractor-employee distinction generally turns on the level of control that a company has over its workers. So the more control, the more uniformity that is imposed top-down from the company, for example, implementing features to every single driver and every single car that are required in order to prevent sexual assaults, the more likely it is that somebody is going to argue in court that these drivers are now controlled to the company by such an extent, they have to do so much of what is required by the company, they have lost the independence that makes them an independent contractor, and instead they are employees as a matter of law. That would be a huge blow to the business model, because these business models rely on treating folks as independent contractors and not having to pay for the protections of employment that come with employee status. And these companies have spent a ton of money fighting laws that would purport to say these drivers, these delivery people, are actually employees. In California, for example, these companies were huge backers of a bill that was passed, making it so that as a matter of law, these drivers, these gig-sharing workers, are independent contractors and not employees. And these companies, for their part, say, look, that's actually what these drivers want. They are getting more independence, and they're allowed to pick their shifts, who they pick up. They're allowed to build themselves up on the platform. They're entrepreneurs in a sort of mini sense. So having many of these requirements could be problematic to both the business model and also make them susceptible to certain legal arguments that so far they've generally been able to get out on top of. There are two ways that a company like Uber could be responsible for the bad acts of its workers: vicarious liability and direct liability. Vicarious liability means a company takes on the responsibility for something that its agent or employee does. Agency means that the person who did the bad acts was acting in a capacity that gave them the power to make decisions on behalf of the company, and that therefore imputes liability or responsibility for those actions up to the company itself. There's a type of agency called ostensible agency, which means that even though that person may not have actually had that power, they held themselves out as an agent of the company. They told everybody in some way, whether it was through a uniform or their actions or verbally, that they had that authority to act on behalf of this company, that people believed them and it was reasonable for them to believe that. And there was ratification, which means that at a certain point, the company became aware that this person, this individual, was acting in a way that made others believe that they were acting on behalf of the company. And then knowing that, the company didn't do anything and basically allowed that person to continue doing what they were doing. They ratified the conduct. That's another way to get at agency. Vicarious liability. Then there's direct liability. That's where I want to focus. Direct liability means the company itself, regardless of what the people in its employ or the people who worked with or for it did, the company itself should have done something or should have stopped something from happening and failed to do that. And because of that, injury or harm happened. Direct liability. Uber's position is that people who commit these acts are unpredictable. You can't reliably predict or foresee bad actors. But the fact is that courts have held companies liable for third-party assaults. Third-party meaning people who are not affiliated with the company at all. So we are just assuming, for the purpose of this argument, that we take Uber's argument about independent contractor status at face value, that these people as independent contractors are not a part of the Uber system. They're not controlled by Uber. We could treat them as third parties. And yet courts have found that there is, in certain circumstances, a responsibility for companies to prevent against third-party assaults. Whether there's a legal duty to prevent against third-party assaults all comes down to foreseeability. Was it foreseeable that this type of harm could occur? You could say that Uber's identification of high-risk circumstances within the system that are correlated with sexual harassment or misconduct claims create this foreseeability, that Uber knew, or it should have reasonably known, that there were circumstances within its platform that made it more likely that a passenger would be sexually assaulted or harassed. That question of foreseeability can come down one of two ways. Now, assume it was a driver and a passenger. It doesn't have to be Uber, it can be any kind of rideshare or even taxi company. Driver picks up passenger, driver assaults or harasses passenger. Was it foreseeable for the company? Well, one of the ways it could be foreseeable is if they had complaints about that driver in the past. Maybe it was something that never quite rose to the level needed to terminate that worker, but it was still misconduct, it was still complaints. Then there's big picture foreseeability, that the data suggested that it was a likelihood. In any given drive, at any given time, a sexual assault could happen. According to the article, which says, one sexual assault every 8 minutes, well, that data would certainly suggest a high level of foreseeability. Of course, Uber would counter and say, well, that data is skewed, those aren't all sexual assaults. So say there was foreseeability and therefore there was a legal duty to do something to prevent sexual assaults. What is that something? Well, it has to do with the standard of care. Now, the general standard of care is reasonableness. Everybody has a duty to act with reasonable care. So the question would be, given that duty, were the steps taken by Uber reasonable? And who decides reasonableness? Well, the jury decides. Sometimes the standard of care is higher than reasonableness, and actually that is the case when it comes to common carriers. Common carriers are taxis, trains, planes, roller coasters, elevators, anything that carries a person from point A to point B. These types of carriers have a special duty. They have a higher standard of care. It's the standard of utmost care. It varies from jurisdiction to jurisdiction, but generally utmost care means that these common carriers, they had the responsibility, the duty, to do everything they possibly could within the scope of their knowledge and experience and foresight to prevent this from happening. Yet still within the parameter of to prevent foreseeable assaults. Foreseeability is sort of like the big upper bound. Nobody has a duty to do something that isn't foreseeable at all, at least not in this context. There are actually laws that do impose liability regardless of whether it was foreseeable. Those are called strict liability. We're not going to talk about that now, but I'll do a video on that in the future. The takeaway is, yes, a company could very well have a responsibility, a duty to do more, especially if there's information that may lead the company to believe something like sexual assault could be a potential in its system. By the way, it's important to know that these questions of duty, liability, even common carrier status have been litigated by Uber heavily in federal and state courts up and down the country, and courts have come out in different ways. So it is not by any means a settled legal issue. There are arguments on both sides that generally are fact-specific, but with an overlay of the law that we talked about today. If you want to dig a little deeper into foreseeability, check out this video that I did on foreseeability. I went into this case that first-year lawyers learn about that really has to do with how foreseeability became such a crux, such a foundation of negligence, of liability. Otherwise, thanks for sticking around, and I'll see you next time.